My name is Steve Houck. I'm here today to interview Bob Hubbard. I had the great privilege of working with Bob at the New York State Attorney General's office in the late 1990s, and I have the distinct pleasure today of interviewing Bob about his stellar career in antitrust enforcement. Bob, I know that you started off life in the Midwest. How did you get from the Midwest to the New York State Attorney General's office?
Well, I moved to New York after college and, did some direct mail fundraising, ultimately went to law school at Fordham. And after Fordham, I went to Skadden for a couple years and went to a small firm, then got a business degree at NYU. So at NYU, I, sort of have to find a job. So it's a question of whether going back to being a lawyer, going to an investment bank, and the AG's office was someplace I interviewed, got an offer, and I thought it meshed with me pretty well. So that's sort of a 30-second to how I got there.
Had you done any antitrust work at Skadden?
Yeah, no, I was in the antitrust department and had done things. And in law school, I'd written my note on antitrust issues. So antitrust had always been interesting to me.
If I'm correct, you had an office mate at Skadden who also went on to antitrust fame. Is that right?
Right. No.
Who was that?
Right. Moselle Thompson was my office mate at Skadden. For about a year, and he was doing corporate stuff. He wasn't in the antitrust department, but lo and behold, a few years later, he became FTC commissioner.
So I think we'll hear later in the interview you had the experience of working with two other folks who went on to become FTC commissioners.
It's really kind of amazing to me that I knew a bunch of people who became FTC commissioners, very early in my career.
So when did you join the Antitrust Bureau?
In September of 1987.
And you've been there ever since?
And I've been there ever since.
So that's sort of unusual. A lot of folks, there's a revolving door. They go in and out of government, but you stayed there all those years. What accounts for your dedication to antitrust enforcement?
Well, I think it meshes pretty well with my personality. I think that with state enforcers, there's actually, I think, less turnover probably than you see otherwise. I think that maybe more in the supervisory roles, there's more turnover. I think as a matter of staffers, there's less turnover. And it's a nice place to work. You get to, if the kind of work interests you, you have nice authority to do things. Mm-hmm. You have the ability to affect how things get done. There are a lot of benefits to someone with my values of that position. And so I stayed, always enjoyed coming to work.
So who was the bureau chief when you joined?
Oh, Lloyd Constantine.
And the Attorney General was General Abrams?
Right. We go back to Bob Abrams.
Right.
And he had, I think it was, he'd been there a while. It was like 82 or so that he became the AG. So, and they actually had hired a bunch of legal aid attorneys mm-hmm. first within antitrust. And when I was hired, they were starting to go to attorneys who had backgrounds at some of these big New York firms. Mm-hmm. So I was one of quite a few hires that fit that sort of characteristic.
And what other AGs have you worked for?
Well, I think I'm on number 5 now. Is that right? Bob Abrams, and then Oliver Capel was the replacement by the Assembly when Bob Abrams resigned, and then Dennis Vaca was elected, and then Elliot Spitzer, and now we have Andrew Cuomo. So what's that, 5?
Right. I wanted to ask you, I'm sure you've heard this as well as I, sometimes people refer to NAG as a National Association of Aspiring Governors. And it's not meant to be a compliment. It's meant to suggest that the state AGs tend to be more political in their enforcement than the DOJ. Do you agree with that? Has that been your experience?
This came up with the Antitrust Modernization Commission and everything else. I mean, first of all, I think that elected officials deserve a little more respect than they get. I think that acting on behalf of consumers and acting on behalf of voters is something they're supposed to be doing. I think that certainly there's a process by which decisions are made. People tend to label those political. I think that that's a process that happens in the federal government, in the state government, and every place else. I think they have different incentives, and political is just a defamatory term to latch on to decisions that you don't agree with.
Yeah. Well, I agree with that personally. I was curious how you felt. Now, I know you've worked on a number of significant cases over your 20 plus years. Could you identify a few that you consider the most significant?
Well, I've had the pleasure of working on a lot of big cases, like the clozapine antitrust litigation was the first antitrust multi-state thing that I'd worked on. The drug manufacturer was tying the patient monitoring services to the sale of the drug, and we challenged that as a tie. Worked on contact lens, in which the manufacturers of contact lenses, refused to sell to mail order and 1-800 companies, and otherwise to disadvantage, so that the optometrists would be better able to sell those products and to otherwise hurt consumers. That went through 6 weeks of trial before we settled. Worked on the Poughkeepsie Hospital case, as you know, that during your tenure. There's been a lot of big cases that I've had the pleasure of working on.
So I think clozapine and contact lens were both multi-state cases.
Yes.
Poughkeepsie Hospital was just a New York State case. Were there other just New York State cases you worked on particularly early in your career?
Yeah, I worked on I was assigned to work on concrete the first day I joined the Bureau. And there were two aspects to that. The first was there was concrete construction bid rigging. It got challenged later as a bid rigging, RICO violation by the U.S. Attorney, and we had a civil claim against them for that violation. So I was assigned that the day I joined the Bureau. It had just there had just been a decision denying their motion to dismiss, and we had to start doing discovery and other things like that. So I was assigned to that and worked on that for a long time. I celebrated 10 years at the AG's office on the third day of trial with the last defendant on the last sort of issue in that. And that was before an appeal, a reversal of refusal to give us damages, and a remand. And so...
Is that the case, by the way, where somebody was assassinated?
No,
case?
Actually, that was a garbage case
it's a garbage
out
case.
online. Yeah, that Bobby Cabecca was an informant to both our office and to the FBI, and they offered to put him in a witness protection program, and he didn't want to go, and he had people on speed dial and stuff, but he was indeed assassinated. I mean, it was really kind of jarring,
I want to talk a little bit about the Poughkeepsie Hospital case, because that's a case that the federal government looked at and then decided not to pursue, right?
Yes, earlier iterations of that, yes.
Right, and the state office took it up, and just to sort of set the background, this wasn't a complete merger, but it was a virtual merger hospital case, and you tell me if I'm incorrect, but I think probably in the last 20 or 30 years or so, the federal government lost every single hospital merger case abroad. And this has been the only successful one. So tell us a little more about how I know you were the principal trial lawyer on this, although it didn't get to trial.
It didn't get to trial. We actually prevailed on a motion for summary judgment. There were cross motions for summary judgment, and we made one on liability and prevailed. We looked at this, and they kept talking about this being a virtual merger and stuff like that, and the more we thought about it, the more we analyzed the transaction, it looked like a cartel to us. That the decision-making authorities continued to reside in the two hospitals independently, and they were deciding how to allocate services, and they were deciding what rates. They were jointly negotiating rates. Looked like a cartel to us, and so we challenged it on that basis and prevailed. And I think, it's interesting, because sometimes they come up with various explanations of why it isn't on the list of hospital litigations, but always there's some reason why it doesn't count. But anyway, so
it's a great result. And you got a great result also in the Rochester department store case, and that was a sort of a cradle of future antitrust stars.
Right.
Besides yourself, tell us who one of your co-counsel was.
Well, and that has a federal story too. They didn't even issue a second request. They, at the time, the FTC. My understanding is they thought that the department store market was much broader than just Rochester, maybe even the entire Northeast. But we were looking at various department store transactions at the time, and this Rochester one came up. And I was working on it. There were various reasons why we had to move quickly, and Pam Jones-Harbor came back from maternity leave and was assigned it to me. So there was a private litigant, and for the state, it was Pam and me. I mean, we had support staff, but in terms of lawyers, there were just the two of us. So,
and for the record, Pam became commissioner on the Federal Trade Commission.
Yes,
so everybody doing this knows, I'm sure, but in case anybody doesn't.
Right. This was.
Right.
Pam had certainly worked at the Bureau for a while, and she'd done some RPM cases and some other things. This was the first time I had the pleasure of working with her directly, and she came back from maternity leave. This was reaching a crescendo, and I was all alone, and she was assigned
trial by fire.
Trial by fire. I think the crucible of litigation is a good thing to.
So we mentioned a number of interesting personalities you've worked with. Are there any other characters that you particularly recall?
It's been an interesting career. There's many people that I've worked with that it's been quite enjoyable. I don't know. The antitrust section, it's been interesting to watch the leadership there and the divergence of personalities and other things.
Are there any particular leaders in the ABA antitrust section that stand out to you?
I've liked all the chairs. They have different personalities for different things. I've always, upon reflection, I came to admire Roxanne Busey. Actually, she was, sort of watching over everything and making sure everything worked well. Mm-hmm. And I think that the absence of anything bad happening and that everybody's views were taken into account and considered. I think that Roxanne did that very well, and she was not sort of loud and anxious to have people see her, but she was very good at making things work.
Quiet and effective.
Quiet and effective. Yes, no, and that's it's kind of I've always valued work and accomplishments more than.
Great. So I'm sure the antitrust landscape has changed considerably over the 20 years you've been at the state AG's office. What stands out to you in terms of what the major changes have been and how that's impacted state enforcement?
Well, I mean, it used to be that you'd find an antitrust violation or what you believed to be an antitrust violation, and you would tell the defendants that you'd tell the parties that you thought they'd violated the antitrust laws, and you basically could work out a settlement. Mm-hmm. And there's been a decision to litigate a lot of that stuff. The change in technology has really been kind of amazing. I can still remember in clozapine that, I'd have a conversation with the clerk about timing and scheduling and stuff like that, and the process of conveying that to all the other states would take quite a while. You'd have to write it out. You'd have to go to the secretary. You have to make sure the secretary's got it right. You'd have to, it was like, 4 hours to do that, which is something that you do in 2 minutes now. And the litigation stuff, the volume of materials you have to get through is really pretty stunning.
So let me just ask you, on that basis, coordination is easier. There's a larger volume of materials you need to review. Does that make it likelier that that states will act together in a multi-state capacity as opposed to one state, do you think, or not necessarily?
Well, when I first started practicing, all the states were basically in the same boat. They had the same claims. They cared mostly about their state. So, you'd bring a case and you'd prevail on the case, and, your boss, my boss, would care about the coverage in, Albany and New York City and stuff like that. And there's the Missouri AG would care about Jefferson City and stuff like that. And so it all worked out pretty well. And the coordination, you had a very big bang effect. With Illinois Brick, increasingly, in order to recover for consumers, you have to find a way around the Illinois brick wall. And the efforts to find the same way around ultimately were unsuccessful, and we ended up pursuing state law claims that were divergent. And I think that those divergent claims make multi-state activity a little more difficult, because you do have divergent claims. There's some that don't have as good a state law remedy, and you worry about whether you're giving somebody else claims that you should be keeping for yourself, and and there's state law decisions on it, and the defendants will hammer on that as best they can. So the divergence of claims and the strategy of defendants has made it much more difficult to sort of coordinate those kind of things and to keep everybody on the same page.
Now, I know that some of that coordination is through the NAG Multistate Antitrust Task Force. And can you tell us how that works? So let's take a hypothetical case. It comes in, say, to New York, and you have to decide first whether it's a good case. You decide it may be sufficiently to pursue. You do that on your own. You take it to NAG. How does all that work?
Well, we're sovereign entities, and even when I was chair of the task force, my salary check was paid by New York State. My first allegiance was to New Yorkers and New York State itself. There are certainly benefits, I believe, strong benefits toward cooperation and to spreading resources, and particularly when you're working on a national matter, there are issues that arise outside of New York State, so it makes sense to coordinate. The task force, there's not sort of a hierarchical. I never became an employee of NAG. It was just a means by which coordination occurred, and that you sort of went forward. Most of the times that we did a multi-state matter, it was, there'd be some reason that you knew somebody else was looking at it, or there was an impact you knew in another state that was significant. So there'd be those kind of bilateral communications with states. The task force is the means by which people talk to one another to see whether there are, they're looking at the same thing. There are impacts that are broader than just in their state, and other things. So that's how it works.
Does the task force have some kind of infrastructure that supports your efforts?
Yeah, there's lots of things that NAG provides in terms of support for conference calls. They also have a multi-state database that collects the sort of history of enforcement actions. They do other things. They sponsor our fall seminar and other training opportunities that get done. We have one of the things I instituted as chair. We always had calls and means by which we would communicate, but I thought that we should talk more regularly, and we had all states calls every 2 weeks. If people wanted to raise issues, they could. Tried to have an agenda about what was going on, and tried to foster the communication as best I could.
You mentioned that you became chair of the task force. Can you tell us a little bit about that, when it happened, and how you got that job?
Well, Trish Connors was chair, and she was stepping down. And the process is that there's a AG level committee that does antitrust. And they are the designated decision makers for who the chair of the multi-state task force is. So they put together an application process for the successor for Trish. They ask you to do various things, put together an application, identify projects that you thought could get done within 2 years, and otherwise sort of specify what it is you want to do. I put in an application, and I'm happy and proud that they selected me, and so that was the process.
Were you interviewed by some attorneys general?
Yes, indeed. It was Hardy Myers of Oregon and Mark Bennett. Mark Bennett was the one who did the laboring oar of this decision-making process. So yes, I was interviewed by Mark Bennett for that.
And did you have specific objectives in mind that you wanted to accomplish during your tenure as chair?
Yes.
And what were they?
The cloud on the horizon at the time for state enforcers was the Antitrust Modernization Commission. So one of my goals was to deal with what AMC was doing. I also thought that we were not as systematic about thinking about merger enforcement as we should. I also thought that we had gotten away from sort of the bread and butter of antitrust enforcement, sort of like bid rigging, local stuff. I thought we should be doing more of that. And finally, I thought that we should think through vertical restraints more systematically and sort of figure out where we were. So it was, dealing with AMC, dealing with merger enforcement, dealing with vertical restraints, and which one am I forgetting? Oh, yeah, the government purchasers.
So you said that the AMC was a cloud on the horizon. I think I know what you mean. But could you explain a little more what you meant, and was it perceived the same way by most other folks in state antitrust enforcement?
Oh, yeah. I mean, they put out Representative Sensenbrenner put out a press release basically saying that you had to think about whether the antitrust laws had to be modernized, and he listed like 4 things that were of question, sort of messed things up. And in his list was state enforcement. Mm-hmm. He did retreat from that in his later testimony and otherwise, but it was fairly clear that there was sentiment against state enforcement, and we thought that there was a pretty large risk that there would be an effort to limit the enforcement authority, to recommend that federal law be changed to give states less rights, and other things. So
was that a widespread concern across the spectrum of state antitrust, Democrat, Republican, big state, small state?
Yes. I mean, they basically were, state AGs agree that they should have more authority, and that protecting consumers and the state are important rights that they should have under the antitrust laws and other laws. So actually, the AMC, one of the things I pushed for and got done. Mark Bennett actually put together with Emily Myers' help, put together a resolution for all the AGs on the issues that were raised by the Antitrust Modernization Commission, and that resolution was passed unanimously. We did a lot of materials that for AMC. I thought that it was important to try to get very high-level people to testify. Mark Bennett, along with Ellen Cooper in Maryland. Mark Bennett, the Attorney General of Hawaii, testified on Illinois brick issues. Rob McKenna testified about regulatory issues, the line in front of the AMC, the line between antitrust and regulation. Steve Rowe, the Attorney General of Maine, testified. And there were other things that were submitted. So it was, Mark Bennett is a Republican, and Rob McKenna is a Republican, and Steve Rowe is a Democrat. And there were other Democrats that participated too. It was very much a bipartisan effort.
So how did that come out?
I think the worst that happened was there was a 7-5 vote about state merger enforcement and whether we should have less rights. But the 7 was on our side, so we basically
pretty much nothing happened.
Prevailed. Right.
So what do you think state antitrust enforcement adds to the potpourri of enforcement? We have the FTC and the DOJ. You obviously believe that the states are a strong component of the enforcement network here. Can you articulate that a little bit?
Well, we live in a federal system, and that federal system has respect and support for divergent views, and those divergent views come from a wide variety of sources, including states. And there's the laboratories of democracy idea, the people with different viewpoints being allowed to pursue interests and seeing what the judiciary accepts, I think has been a very important part of creating a dynamic system that doesn't get bureaucratized, that can't be prevented, that can't be eliminated by a single decision maker in Washington or otherwise. There have been times when I think state enforcement, kept alive various theories that would have otherwise died. I think a lot of vertical issues would have died without very aggressive action by states. There are other things that I think I think the states don't get as much credit as they deserve on international issues. It was the state's case in the insurance industry, Hartford Fire, California v. Hartford Fire, that established the extraterritorial reach of the antitrust laws so that companies like Lloyd's of London, if they put together restraints that impacted New York consumers and every other consumer in the United States, you had the reach of getting that, and there's sort of an oozy standard under the federal antitrust laws until that went to the Supreme Court, and we won that pretty handily. So I think that all those sort of divergent views gets a better result at the end of the day. It gets less bureaucratized, and it challenges people's thinking. So I think that there's just, I think it's a great system that got set up. Federal systems, a federal system generally, and as it plays out in antitrust, I think it works quite well.
I know the states work closely with the federal enforcement agencies. How has that relationship changed over time?
On a staff level, it's variable. I think generally it's pretty good because we think the same way. I think you work in the DOJ Antitrust Division at the FTC as a staff attorney because you think competition is a good thing that you ought to protect. So I think that fundamental consistency has enabled cooperation. There's been ebbs and flows on this. Prosecutors, like everything else, get a little territorial every so often, and states are subject to that. The federal government attorneys are subject to that. I've always felt that the FTC understands us better. I mean, they have 5 commissioners. They have a 5-headed hydra. You can't, it's 5 votes. They sort of understand the dynamic of independent decision makers a little bit better. They also have a consumer protection leg that gives them a perspective that I think helps them understand us a little better. So I think we've always gotten along quite well with the FTC. There have been some times and cases. But generally, it's been quite good. DOJ is more sort of hierarchical, and it's very much more hierarchical. One decision maker, and that decision makers can sometimes have some pretty significant impacts on the level of cooperation. And they'll always say that they're cooperative, but when the rubber meets the road, it's sometimes a little divergent. At this point, it's I really find it really pretty amazing, the level of cooperation, the respect for divergent views, and the efforts at transparency and otherwise. I think that the cooperation is right now quite good.
You mentioned that you worked with Pamela Jones-Harbor, who was a federal trade commissioner, and she just stepped down, and she has been replaced by Julie Brill. Have you worked with Julie Brill?
Well, Julie Brill was in Vermont for years and years and years. She did a lot of antitrust work. She also did a whole lot of, consumer protection work in pharmaceuticals and otherwise. So, yes, I've talked with Julie many times. We've been on cases together, worked on things together, from like pharmacy mergers that, hit the entire Northeast, and they hit Vermont too. to pharmaceutical matters that we work together on. She's attended NAG meetings and I talked with her. She was a classmate of Elliot Spitzer, so she would tell stories that I enjoyed hearing. So yes, I've known Julie for a long time. I think that it was a very good selection. I think that I was very glad that Julie was nominated and confirmed. I'm sure it'll be an adventure for her, and it's nice to see that. And so I guess we're at three, right? Moselle Thompson,
Right,
Pam
yeah.
Jones-Harber, and Julie Brill.
Right, so you think
I'm on my third.
I think it's a good thing to have some state representation at that level. At the federal agencies?
Absolutely. I think that states bring a practicality and a rubber meet the road kind of mindset that I think is very beneficial. I think that Julie, more so than other people, understand how those policies impact individual consumers. I think that the insight she got from doing that work in Vermont, is something that you can't really replace. So I think that yes, all of that is quite useful. I think that the more and more the sort of consumer protection issues and the antitrust issues are sort of melding together.
Mm-hmm.
And I think that Julie is very well situated to understand those intersections and when a consumer protection tool works better than an antitrust tool, and when competition advocacy ought to be used more than, for example, an antitrust claim. And there are other things that I think Julie is very well situated to understand and push, and I look forward to.
I know that one of your signature issues has been vertical restraints, and in particular resale price maintenance. Can you talk a little bit about why that issue is so important to you, why you think it's such an important issue?
Yeah, no, I mean, it's I just can't get beyond the fundamental point that vertical resale price fixing is about raising prices for consumers. And a large part of my job is to protect consumers. And how people think raising prices for consumers by an agreement is a good thing, just as, how they can justify that just goes against my gut so fundamentally. And, as I mentioned, one of my four things in when I became chair was to talk about vertical restraints. It had gotten to be a mess. The litigation strategies that we were facing had gotten more and more pronounced and difficult to deal with. And I can't remember exactly how the timing was, but all of a sudden there's this pro forma affirmance of a jury verdict in the Fifth Circuit. Fifth Circuit just affirmed this. It's clear. This case law is clear. And all of a sudden, Justice Scalia, acting on behalf of the court, stays the mandate. And there's going to be a Supreme Court decision on resale price fixing. The effort to focus on vertical restraints became more and more focused on dealing with Legion. We put together a New York amicus on that. We got 37 AGs to join. We had the New York Solicitor General she had been the Solicitor General for the United States, acting maybe just, but she was at the end of the Clinton administration, and she argued in front of the Supreme Court on this. Saying that raising prices for consumers by an agreement is not a good thing. Everybody, I think, when this first came down, thought we were going to lose 9-0. We only lost 5-4. There are things in the majority's decision that a plaintiff thinks are appropriate, and there are state law arguments and otherwise. So I just. The kind of justifications for, when you get a call from a consumer and they're talking about, how prices are high, and they say that there's an agreement between the manufacturer and the retailer to set that price high. I've never been able to persuade a consumer I'm not inclined to persuade as a consumer, but I've tried to explain to them why the Supreme Court thinks that that might be a good idea for them. And you can tell that they're just rolling their eyes. How could a higher price by consumers be good for consumers? There's just a fundamental disconnect. And so I felt it was necessary to swim against the tide. Maybe it was up the waterfall, but I just think that it's such a we've lost. We keep talking about consumer welfare, and we keep talking about the purposes of the antitrust law. And here you have a restraint whose purpose and effect is to raise price for consumers. How people don't, and the antitrust bar generally agrees that resale price fixing ought to be okay usually. And it's just mind-boggling to me that if we're talking about consumer welfare, how a higher price for consumers is good for them.
I know that RPM has been one area of state focus over the years, and it's sort of been a domain they've been the principal enforcement agency in rather than either of the federal agencies. What has been the impact of Legion on the states in terms of their enforcement priorities?
Well, the resale price fixing had the benefit of not getting hit by Illinois BRIC. So you didn't have an indirect purchaser problem because the agreement was between the retailer and the manufacturer, and you didn't have to worry about Illinois BRIC. So it was at the core of what states did in the representation of consumers. We had a lot of those cases. They worked out very well. Everybody was on the same page, didn't have to worry about Illinois BRIC. All you had to do was prove the agreement, and then you were done. There were problems with proven agreements, and there were other things. It's not an easy case by any means, but you could get it done. With Legion, there's so much uncertainty about how this is going to shake out. Because the per se rule had been so entrenched, people had not really thought through the policy issues and whether they're the kind of basis for the arguments in support of resale price fixing, the proponent, whether those made sense, whether they could be documented or otherwise. So, state enforcers, like other enforcers, try to get it right. So the Legion has caused a lot of consideration of the theory, of the actual impact, the extent to which you can document those things. The scholarship has been quite amazing. The FTC had hearings on this, and there were other things that have gone on. So the states, like everybody else, are trying to think through what public policies make sense, whether the arguments that the majority did in Legion are justified, should impact how we make enforcement decisions. And it's taken a while to think all those things through.
Do you think we will see RPM cases from the states post-Legion?
Yeah, we've seen a few. New York, along with Michigan and Illinois, settled a case with Herrmann Miller shortly after Legion. There was a North Carolina case in which, in the oil industry, a jobber case that was settled also, the RPM case. California recently had a case, and New York recently filed a case against Tempur-Pedic. And the California case was under state law, as was the New York case. I think that there'll be some challenges in aggregating those views. If you have to operate under a Legion as opposed to a state law per se rule, there are more difficulties with putting the case together. It's hard to know how this will shake out, but I think that people have thought through the issues. There are people that are more and more cognizant of the harm caused to consumers. There was a panel yesterday at the ABA antitrust section meeting. I don't think I saw a panel before that had 3 people in favor of strong enforcement against resale price fixing.
So Legion may have interesting, unexpected effects.
Well, I think that it did have the effect of thinking through whether the policy makes sense. and what the actual impact is. I think that at least my read of the commentary is that they basically can't prove the justifications, and if they can't prove the justifications, I think that if a plaintiff proves that prices go up by reason of the restraint, plaintiff ought to prevail. But it's not clear whether a court would agree with that view in the federal system.
One of your prior answers, you mentioned Illinois Brick. Is that the other Supreme Court case in the course of your 20 years that's had the most impact, do you think, on state enforcement?
Yeah, well, Illinois Brick was, yes, before my time, but in terms of securing a remedy for consumers, having to have basically contractual privity between the victim and the antitrust violator does end a whole slew of claims. So we have a complicated economy where there are usually lots of layers, lots of people who do lots of things. The manufacturing process, you make one thing, it gets put into something else, that gets put into something else, it gets put into something else. So Illinois Brick, had the effect of making a remedy available for consumers much more difficult. And so,
how the states worked around that?
Well, we originally tried to develop some federal law arguments around it that didn't really work. We first tried to get Illinois Brick read narrowly. That didn't really work. We tried to pass federal legislation. That did not work. We developed state law arguments. That actually worked. There were a lot of divergence there. I personally think that there was another federal law argument that we made in the Mylan case, lorazepam clorazepate, which was basically as a disgorgement remedy. We ought to be able to recover restitution or something under Section 16 of the Clayton Act. That this was impacting consumers, and that as a matter of a court exercising his or her equitable authority, there ought to be a monetary remedy for that violation. Judge Hogan rejected that. It's only district court level. Maybe it's time to revisit those issues. I think that just from a systemic perspective, the divergence of the claims that state AGs have makes it easier to engage in divide and conquer tactics, to get further and further removed from the substance of the impact, and to be talking about tracing and causation and other things. Right.
We're getting near the end of the interview. Before it's over, I did want to ask you a little bit about your Bar Association activity. I know you're very active both in the ABA and the New York State Bar Association. Can you sort of briefly describe what you've done and obviously why you think it's important?
As are you. I think you were a chair of the antitrust section, right. As a state bar before me. I've always found it useful to talk with people with divergent views. And the Bar Association, when I started becoming active in the state bar, it was mostly defense bar oriented. And I welcomed the opportunity to respond to the views that they had and to try to persuade them that they should temper their views. I find Bar Association people are more amenable to hearing and understanding the views of others. I think that it's honed my thinking, developed my advocacy skills. I think that I've always valued results, worked on books and other things. I think that Bar Association's efforts has been very useful in understanding the issues, developing advocacy skills, understanding the views of others. I've always liked Bar Association stuff.
Bob, I want to thank you for taking the time to talk with me this morning, and I also wanted to thank the ABA for making this possible.
And thank you, Steve.